Ms. McCurry?
Yes.
Okay, I believe you need to turn to your right if you can, so you'll be facing the camera.
Okay. All right. Let me turn.
Thank you. Okay, call the case, please.
Benjamin McCurry versus Agness McCurry.
All right, we'll hear from the appellant, Ms. McCurry. As you know, Ms. McCurry, you have 15 minutes.
Okay.
You
So it's not 11 yet, it's 10:54. Am I starting early?
yes, everybody's ready. You were on, and we're ready, so we figure we'll go ahead and start.
All right. May it please the court, sorry, let me just get my stuff. May it please the court, good morning. My name is Agness. I am the appellant in this matter. I did request for additional time, but I wasn't provided with that time, so I'll just do my best to present everything. So the appellee, Benjamin McCurry, decided not to participate in this appeal. And I just want to start by making the point that the trial court judges in my divorce and child custody case, they always ignored the evidence of domestic abuse by the appellee, Benjamin McCurry, who is listed as my abuser with the Department of Homeland Security under the Violence Against Women Act. The vow allowed me to gain lawful permanent residency in this country. The evidence of domestic violence, it is an important factor in my divorce and child custody case. When I look at the case Brent Dwayne Carr versus Kelly Renee Carr, I saw that in this case, there was a modification of the father who was the primary parent due to evidence of domestic violence. It is an important statutory factor because they equated abuse to the other parent as abuse to the child. And that's 36-6-106, and that's the statutory factor number 11. In my case, all the trial court judges allowed my abuser, Benjamin McCurry, to terrorize me and my son. This appeal specifically was evidence of continued post-divorce trauma. The trial court judge had ex parte communications with counsel for Benjamin McCurry on July 7, 2023. And drafted an order to punish my son and I to communicate by email and text message only. Because when you look at the record, it specifically states that the order was entered on the 7th of July, but then it was filed on the 14th. So this was already a predetermined verdict. The actions of the trial court judge, it violated my due process rights under the 14th Amendment. And the best interest of my son to appease Benjamin McCurry and his then fiance who were practicing cohabitation against the May 6, 2022 order and the parenting plan. Cohabitation is not biblical because the marriage bed is undefiled and to be held in honor. And that order, the May 6 order, is specifically stated that the child is to be raised by Christian biblical principles. And this order can be found in the first appeal, E-2022-00635. So the May 6, 22 order, it was not really reviewed in my first appeal. And that's why it's posed a lot of issues in this second appeal when I discovered the unlawful cohabitation. And that opinion, it ended up allowing the appellee Benjamin McCurry to continue abusing the minor child, which is still a violation of the best interest of the child statutory factors 36-6-106, and that's 2, 8, 11, and 12. So when this court affirmed the ruling of Judge Lauterbach that dismissed my motion for criminal contempt and emergency custody of the minor child, it basically caused a lot of harm to me and my son, which resulted to this appeal. So Benjamin McCurry is registered as an abuser under my Violence Against Women Act petition and is found in the record for my first appeal, E-2022-0635. So I felt that the trial court judges, the Court of Appeals judges, and even when I subsequently appealed to the Supreme Court, they basically supported the appellee to continue abusing me and my son. I know for a fact that domestic violence is abhorrent and outrageous conduct. and is not tolerated in our civilized society. Domestic violence, it claims lives statistically of 1 in 4 women and 1 in 9 men, according to research by the National Coalition Against Domestic Violence. Courts are supposed to treat people with impartiality, fairly and properly, and reasonably by the law, and by the arbiters of the law. That due process is preserved in all proceedings to ensure that no harm befalls another. And where harm is alleged, a remedial action is taken. Both the accuser and the accused must receive a morally right conscience, merited by their actions. And I adapted this from the definitions of justice from Cornell education. So when I petitioned the Court of Appeals and Supreme Court to review the decision of the trial court in my first appeal for the best interests of my son, none of this was achieved. So regrettably, I felt that the courts have shut their ears to the issues and arguments that I raised in that brief. The presiding judges, all of them in my case, because subsequently after Judge Lauterbach, there's now Senior Judge Thomas Wright, and he has now announced his retirement this August 31st of 2023. So they have waged war against the best interests of my son, in the best interests of the appellee Benjamin McCurry and his current wife, because my son is currently being abused, and I have not seen him for no reason at all since September 29th of 2022. So I felt, and I still believe, that somehow there must be a strong relationship between the Court of Appeals judges and the Court of Appeals judges, the Supreme Court judges, and the trial court judges in my case. Because I don't understand how the strong evidence of domestic violence is being ignored. Because the Violence Against Women Act, it is a federal bill. It is federal law. And the fact that I mentioned this in my brief, both briefs, I don't understand why that is being ignored. What I would like the judges to consider
Ms. McCurry, what proof did you present as far as domestic violence?
The Violence Against Women Act petition, this document was always ignored. My first appeal is in the record. Okay. Although when I tried to
I understand that, but what proof that you presented that there was actual violence directed to you or your son? Was there any police report, any complaints that was made to the local authorities of violence?
Yes, there was evidence of that, including my therapist's records, but the Violence Against Women Act is the strongest evidence of abuse. Because when I testified at the divorce trial, I gave all that testimony, but sadly there was no court reporter. Because the Violence Against Women Act, it is federal law. It establishes that I endured extreme cruelty. I provided all that evidence. When you look at the United States Citizenship and Immigration Services for the VAWA, it lists the criteria. I provided the police reports. I provided the evidence of my domestic abuse advocate. Her name was Toni Callan at the time. So she even accompanied me at my trial. When I had my divorce hearing, she was present. So I provided all that testimony of abuse, but it was ignored. And that's why when you look at the record for the findings of fact and conclusions of law of February 22nd of 2019, the VAWA is not listed, but it was presented and the judge admitted it into evidence. It was at prima facie status. So I did give the testimony and I did give those exhibits, but when I tried to have them supplemented, the court denied them. So the evidence was there, but the court just never received them, but I did make an effort.
That was on your initial divorce. Now, when you filed the petition for emergency custody, was there any proof at that point presented toward domestic violence?
Well, when I filed for emergency custody, the main issue, and that's the issue in this appeal, is there was a violation to the court order, which is the May 6th. So if you look at the record of E2022-00635, there's the May 6th order, and it specifically orders that the minor child be raised by Christian biblical principles. And because when I discovered the cohabitation of Mr. McCurry at the time with his then fiance, I had been making an effort, as I noted it in my petition for emergency custody. He was keeping his address away from me. And if you read from the transcript of that first appeal, it also states from there that, if you read it, he was already practicing it, but I didn't know. He said he was acclimating the child slowly by leaving the child with his fiance without my knowledge. He never filed a response in that appeal, and that's why I was wondering how it was automatically affirmed by this court. It was supposed to be a default. His attorney, Donna Bolton at the time, she didn't even file an appearance. So the trial court judge violated my due process because he became the judge and the attorney for Mr. McCurry, because he was making arguments for him that can be seen in the transcript. He didn't provide a response at all, and all of my petitions were dismissed. Because that was abuse to my son even then. I raised those concerns. He withdrew him from preschool because he hid a serious traumatic injury of my son to the ear. It's in the transcript. My son is always the one who provided me information. I made that clear.
Ms. McCurry, let me interrupt you a second, please. So
Yeah.
what's on appeal now here is your argument that the trial court erred, because that's all we do. It's all we can do by law is look and see
Yes.
whether or not the trial court committed reversible error.
Yes.
So what you're saying is, what you were arguing there was that because the child's father had his fiancee staying with him, that required emergency custody be transferred to you, and the trial court said no. Is that correct? That was your basis for the emergency custody petition?
No, because the basis of my appeal is that and other factors. So what it is that I discovered.
Well, okay, but we can only look at what's up here now in this case.
Yes.
So what was the basis? What was the basis for your emergency custody position? What were you arguing to the trial court that required a change in custody?
So I actually want to add something before I answer your question. I did read an opinion. It's called Chase versus Stewart. And in that opinion, I learned that when you raise an appeal, like the way I've raised my first appeal, E2022-00635, I did talk about it in this appeal. So it requires this court to also review that appeal as well, because I've raised it up as an issue too. Because I looked at that opinion, I read it thoroughly when the reversal of the sanctions against the attorney's counsel Manukian, that's what happened in that appeal. So in this appeal, I'm basically showing that there was due process violations, because if you look even at the order that I appealed, it's two things. I appealed the order denying emergency custody. I also appealed the joint mutual restraining order that was entered.
Yes.
Because it was entered on the 7th already by the trial court judge. It was premeditated. And that has been shown by clear and convincing evidence. If you look at that order, it was entered on the 7th. The same day he denied my emergency custody order, but then he filed it on the 14th. Because the 14th of July is when we had the trial, which was supposed to be for Mr. McCurry's his order of protection, but the judge denied that. And then he appealed that, and that's the hearing we had on the 14th. So when the judge actually filed that order, and I received it, I actually quickly learned, because I was deprived of due process. If you read in the transcript, the judge said, I will give you the opportunity to testify. So that he misled me. It was false pretenses, because he strategically allowed Mr. McCurry and his fiance to testify, and then I was blocked. It is stated in the transcript. The judge, Judge Lauterbach, he said, I won't let you testify because I'm dismissing his order of protection. So it should have ended right there. But he, sua sponte, decided to enter a joint mutual restraining order based off of the testimony of Mr. McCurry and his then fiance. So that already was a clear due process violation, because how was my mother-child relationship with my son affected by the testimony of another woman who is not the biological mother to the child? And that is very serious. So when I looked at the order and I realized that what happened to me on the 14th was actually premeditated, it justifies that that order should be vacated completely for due process violations. And I argued that in my brief, because it's shown by clear and convincing evidence before the Court of Appeals. That is a violation of the best interest of the child statutory factors, because Kelly Ray, at the time of this hearing, she had no grounds to have testimony, and her testimony was basically even showing, she said, this, like when I discovered her cohabitation with Mr. McCurry, she said herself that where she lived is her home, it is her peace. But my son was there. My son was there. Why was that happening? I have rights as the biological mother, so she had no right to even have, as you can read from the transcript, my son even had his own bed. So all of that was justification to show that this is cohabitation. And I want the appellate court judges to know I am very passionate about my faith. I am a very serious Bible-believing child of God. So when I didn't like that situation, because there was a lawful court order that said Christian biblical principles, it is immoral for the appellate Benjamin McCurry to have kept my son in that environment, because it violates the parenting plan, and also the May 6th order. That's clear contempt. That is clear contempt. Now, of course, that's not the issue raised on appeal, which is contempt. The issue I've raised on appeal is the joint mutual restraining order and the emergency, the denial of my petition for emergency custody. Because as you can see from the record, it's clear. The order is entered on the 7th, but filed on the 14th. And the order itself, because it was entered on the 7th, it was premeditated by the judge. He knew he was going to punish me and my son to communicate by text message and email only. How can you communicate that way with a child? That went against the parenting plan, because the parenting plan stated I have the right to uninterrupted phone calls. But now it's entered an order that violates the parenting plan and the best interest of the child statutory factors. And that's what I want the Court of Appeals judges to consider, because it's very clear. And I was not very happy, because the way the first appeal, it consisted of personal attacks against me. I read that opinion, the E2022-00635. I was now being told new rules at the Court of Appeals, and I've read opinions. I raised multiple issues with that order in my first appeal, but I was told in that opinion that there's now a limit on the number of issues that you can raise on appeal. I have the opinion right here with me.
I'm sorry, Ms. McCurry, you've used your time. We've actually given you, I think, 2 or 3 minutes over the 15 minutes, so your time's expired.
Okay, well, I don't feel like this was a fair oral argument, because it even started before the time.
Ms. McCurry, you were given your full 15 minutes.
Okay, that's all right. Like I said, I don't even feel like I've been heard, but I'm so glad, because I recorded this entire oral argument.
Yes.
To show the due process violation still. So it's all right.
All right. You actually were given, I think, 18 minutes total before we cut you off.
Okay.
So you were given more than the 15 we told you would be limited to. If you would, recess court until this afternoon.
This Honorable Court of Tennessee is now in recess.
Thank you.
Thank you.
Thank you.